As guest Megan Kurz may be joining us.
Okay, great. All right. Oh, there she is. Oh, maybe we're still letting people in.
Yeah, that's what I was gonna say before the recording was started.
Okay. So the recording has now started, and I'm gonna get going. So good afternoon. My name is Haley Lyons. I'm calling. Did someone just pause me? No, nobody paused me. Nope, I paused myself. Okay. Calling the meeting to order. Starting over. Let's call the meeting to order at 12:02 p.m. on August 11th. I almost said April 11th, which would have made all of you tax people cringe because you'd be like, we're not going to be here then. Good afternoon. My name is Haley Lyons. I'm the chair of the Board of Accountancy. I'm calling this special Zoom only public meeting of the State of Oregon Board of Accountancy to order. Today is Monday, August 11th, 2025. It is 12:02 p.m. This meeting is held by Zoom with most staff participating from the board offices on 200 Hawthorne Avenue Southeast, Suite D450, Salem, Oregon 97301. This meeting is being recorded. For all Zoom participants, please be sure to mute your microphone and unmute only when you are called upon to speak. Please do not use the chat room for any discussions. Should any technical issues arise, the meeting will be paused until they are resolved. I will now take a roll call of all members and guests. I will start with whom I can see on Zoom, followed by staff at the board office. So Haley Lyons, and I'm just gonna do a roll call essentially. Megan Hartley.
Megan Hartley, board member.
Thank you. Jason Robinson.
Jason Robinson, board treasurer.
Thank you. Logan Steele.
Logan Steele, board member.
Thank you. Raul Valdivia.
Raul Valdivia, vice chair.
Great. I think that's all of our board members. So we're gonna go to board staff. Martin.
Martin Bacchioni, executive director by Zoom.
Great. Quinn.
Quinn Stoddard, board staff by Zoom.
Thank you. Andrew.
Andrew Barlow, board staff in office and Zoom.
Thank you. Jeremiah.
Jeremiah Leppert, board staff in office and Zoom.
Awesome. And then we'll move to our guests. Sherry.
Sherry McPherson, OSCPA guest.
Awesome. Amanda.
Amanda Fells, OAIA guest.
Great. Megan.
Megan Kurz, OSCPA guest.
Thank you. Tanya.
Tanya Moffett, BOAC chair.
Thank you. Ray.
Ray Johnson, member of the LRC.
Thanks, Ray. Jason.
Jason Orm, chair of the LRC. the other Jason.
The other Jason. Shelley. Which we'll do an introduction here in a minute, but just say your name.
Shelley Osterom, incoming deputy director.
Thank you. Brandon. Very cute, Brandon. That was lovely. This is now the third time this has happened in a Board of Accountancy meeting, which is like fascinating to me. Welcome, Shelley. And like really, like this is the group you're really going for? Okay, cool. Elizabeth, would you like to introduce yourself?
If I can stop the shock. Okay. Holy smokes. Hello. Can you guys hear me okay?
We can.
Wonderful.
Nice,
thank you. I'm zooming in from visiting family. Elizabeth Ulmer, Portland State University. I'm a guest.
Thank you. Yeah. I could sense when I joined that Quinn, you were trying to like convince that dude to like do his thing, and I was like, okay. I had a sense that was going to happen.
Please
Didn't you?
On the record.
Huh?
Please don't blame me while we're on the record.
I'm not blaming you. No, I could tell like when you were asking the questions of him, like you're going to have to introduce yourself, that it was like, hello, get ready for this. And
it felt vaguely like deja vu.
It did.
Yeah.
Yes, 100%. So.
Madam Chair.
Yes, sir.
Madam Chair, just for the record, I also believe that we have board counsel with us. It's just not obvious from what you can tell, because she's in the same office as Jason Orm, where I hopefully will be shortly.
Hello.
So Angie, can you introduce yourself for the record so
Yeah.
that we have a full
Angie.
record?
Angie Hunt, Board Counsel, can you hear me? I wasn't sure.
Yes.
Okay, great, I'm here, but I got to miss the video.
Well, at least it wasn't on the big screen. Okay.
Yeah.
Here we go. So anybody that I have not recognized yet, that is here. Great. Okay. So agenda review and approval. Hopefully everyone had a chance to review the agenda. And does anyone have any proposed amendments to the agenda? Martin, would you like to propose an amendment?
Madam Chair, if we could do a very brief introduction of new staff.
Yes, please. Go for it.
Well, that's kind of the agenda amendment. So we
Oh,
first
okay,
have to amend the agenda.
We're going to add the, right. So does anybody else have any other amendments to the agenda? Hearing none, can we have a motion to approve the agenda as amended?
I make a motion to approve the amendment as the agenda and its amendment as presented.
Thanks, Jason.
Megan Hartley, I
Logan Steele here, I
second.
second.
Great. Awesome. And then we will do a quick roll call vote. Haley Lyons, aye. Megan.
Megan Hartley, aye.
Logan.
Logan Steele, aye.
Jason Robinson.
Jason Robinson, aye.
Ralph Valdivia.
Raul Valdivia, aye.
Awesome, thank you. Okay, so we are going, the first item on the agenda after the agenda review and approval is an introduction of new staff. And hopefully that still remains to be new staff after the 5 minutes.
Oh boy, what a welcome to new staff. So folks, very briefly, as you recall, the budget authorized a new deputy director position, which was immediately posted basically within 24 hours of the governor signing our budget. So we wasted no time, and it's my very distinct pleasure to announce that this morning we brought that search to full completion, and we have with us the incoming deputy, Shelley Ostrom. And Shelley, could you very briefly go, if possible, go on camera and briefly introduce yourself, and then we'll proceed with the rest of the board meeting.
Sure, thank you, Martin. It's a pleasure to meet you all. My name is Shelley Ostrom. I hail from the tiny town of Almsville, Oregon today. Just a very brief background about myself. I spent the last 22 years employed by the Internal Revenue Service. 20 of those years were spent as a revenue officer, tax collector. I specialized in abusive tax avoidance transactions and international tax evasion schemes. The last 2 years I spent as a project manager and data analyst in the IRS Office of Fraud Enforcement. Our primary goal was to identify and mitigate fraud and come up with proactive solutions to prevent it ahead of time. Thank you.
And as I suspected, Shelley's being modest and she skipped over her Navy career. Do you want to just very briefly just give us one sentence about that piece?
Yes, I'm a retired Navy. I was in an outfit called the Navy Seabees. We did construction work. I'd be one of the few people in the Navy who could tell you I never been on a ship.
Nice. Well,
All right.
awesome. Welcome, Shelley. Thanks for being here today. We would have hated for you to have missed the excitement. Okay, so we are moving into public comment. Are there any members of the public who wish to comment? Please use Zoom. And you don't really need to raise your hand. You will be permitted to address the board for a maximum of 3 minutes, and staff will unmute you so you can speak. As chair, I reserve the right to end your comment early and have staff mute you if your comment does not pertain to the authority given to this board by the legislature to regulate the CPA profession and public accountancy firms in the state. Any public comment? Seeing none, we shall move on. Review of the public board meeting summaries. You were provided with a summary of the June 5th, 2025 board meeting. Any comments on that? Nope, no motion is required here. And so now we're moving into old business. The June 5th, 2025 work session, we had a request for clarification, further direction from the LRC on board policy objectives with respect to firm registration requirements and minority ownership structures. And then Martin provided some additional materials. He has now gone off camera, but there is, we do have some discussion that needs to happen around that. Jason, do you want to jump in with that, or Martin, do you want to add a little bit more color?
Sure. Basically, and I don't quite know what's going on with my phone. My phone tells me that I am on video, so hopefully you can.
Oh, you are. You are now. You're back.
Hopefully you can see me. So basically, what ended up happening is that we had a, wonderful discussion on June 5 at the board meeting around these really difficult issues around private equity. And then things started kind of shifting a bit in two ways. One is that one part of that discussion took place under the impression that one of the most prominent West Coast firms was going to undergo an acquisition by private equity that would not involve an APS structure. And that turned out after the board meeting to be inaccurate. And that's one of the reasons why there was some uncertainty, not the only reason, but that was one key reason why at the Laws and Rules Committee meeting that followed the board meeting, there was some uncertainty on, number one, whether the board essentially was driven primarily by the consideration of what happened with Moss Adams when it basically directed the Laws and Rules Committee to say, hey, we would like to do, among other things, a legislative concept that would open up the CPA ownership structure at the minority level to private equity, even if that entity is involved in attest services. And that was essentially, there was then a question of, was that the board's intent simply because of what we thought would happen with Moss, or is that essentially something the board feels we need to do no matter what happened with Moss or not, that it doesn't matter what ended up happening with Moss? So that's one kind of big component. And the other big one, and this is a super high level summary, and I'm sure that, Angie and Jason will come in more eloquently maybe than I'm doing right now, but the other super high level piece that happened that I think also, quite frankly, Angie gets credit for really kind of rattling our cage a little bit. And she basically said, hey, if we're going to go in with a legislative concept that basically does what Angie recommended we would do and what the board asked we do, which is, hey, on the firm registration side, could we essentially require all firms to register, but then give the board explicit authority to exempt out firms by rule? That effectively, unless we use that new structure to come up with actually something different with respect to which firms we expect to register or not, then that's a little bit too risky of an enterprise. And so what the LRC really was looking for is getting real clarity on this other issue of the firm registrations, is what is the board really specifically trying to accomplish in that arena? That's the super high level summary. There's a little bit more detail in that memo that hopefully you've had a chance to see and excitedly ponder all weekend. But that's kind of what my high level intro is. And I hope that that's helpful to kind of have that oral summary.
Yeah, thank you. So if we zoom out to the 10,000 foot view and think back to exactly that question of like, what are we trying to accomplish? And then we can kind of get into the sort of tentacles of what that means. You know, our charge as a regulatory board is, you know, regulation of our professional licensure and protection of the public. And so who do we want to define as the public is what I kind of keep coming back to. And it seems as though I'm going to broadly say, rest of the country wants the public to only be users of audited, reviewed financial statements. Something that has to deal, you know, that's done in the attest space, that those users are the only public that we actually need to protect in some ways. Now, obviously, the CPA individual is their license is being regulated as an individual. But what I struggle with is how we effectively regulate those CPA licenses of those individuals without an associated firm when one exists. And it comes down to the enforcement component, right? Where, so if, you know, if somebody acts improperly while working for XYZ tax firm, and then, you know, they have to figure out a way, if they have a complaint against them, to defend themselves or provide information for the investigation. But also, if it's 6 months later and that individual no longer works for that firm, how does anybody get access to any of those records? So Jeremiah then is attempting to investigate an issue where nobody has any obligation to like give them anything, and the licensee can't provide their own information. And so I struggle with how we actually enforce any, like, so it feels like we're actually limiting what we're going to actually regulate and what we're going to, you know, have enforcement on to CPAs in attest firms versus CPAs also doing tax work, because they're just going to be too hard to enforce. And so that's kind of the like sort of squiggly way I get to like, I think we still have to regulate non-attest firms, or that I still want to regulate them, but that's my thought process there. I'm brainstorming. Does anybody disagree with that? Like that's our end goal, is that we're still like we're still trying to hold firm enforcement, tax firm enforcement as an outcome here.
Just one thing to point out, this is Angie. Just one thing to point out, that the other sort of like overlapping thing that we have to keep remembering, right, is the structure requirements for firms, right? So that's the bigger,
Well, it's not that. It's the bigger, it's not that, to me, I'm above that level. In other words, like we got the structure, that's a byproduct. We have the structure issue, but what we need to determine is if we, like currently we have a problem because people can't register their other half of their APS as a firm on the tax side, or because they're not majority owned. Do we want them to register is I think the big question. Do we want them to be right, as opposed to just, do we like that structure? Jason Robinson.
So is it okay for us to step in the tax realm?
We already are, right?
Ish. But from the standpoint of, we're regulating each of those CPAs that are in a non-registered firm. So we still have some regulatory authority.
Mm-hmm.
Is it going to be seen as overstepping our bounds if we're trying to regulate everybody?
We already regulate everybody.
Ish.
Talk more about that ish in your mind.
Well, so if it's not an attest, and they're doing taxes. They have the opportunity to register with us. Is it required?
It's pretty much required unless you're a solo practitioner.
Or H&R
Right.
Block.
Yeah, it's a whole other ballgame. But essentially, from a policy choice perspective, we're caught between two things. One is that we have broad authority now in the tax space, meaning firm level registration and individual level registration. And that effectively what's happened around us in the rest of the country is that the rest of the country either never regulated the tax space as broadly as they did the attest space, meaning firm registration was only required if the firm was using CPA in their name, roughly speaking, or you ended up having a situation like what we just had in Washington State in the last 5 years, that they had Oregon's approach of broadly regulating firms and then retreated back to, we're just going to broadly regulate in the attest space and require firm registration there, but on the other one, we're going to align with the rest of the country. So either we align with the rest of the country or we keep on trucking with what we have, right? Which then opens up the challenge with respect to then what do we do with the tax entities if we're going to keep going that are majority PEO, right? So that's essentially kind of the fundamental choice that we're facing. And I hope that that helps as an explanation.
Well, and maybe, and then Logan, I definitely see your hand raised. What you just said though, Martin, about kind of the rest of the country, and I said it too, it didn't like settle into my brain space. Maybe we don't have data to support this like inability to effectively enforce without like a firm. Like I'm like tied into this, like if I don't have a firm to like sort of go after in the event of a licensee acting inappropriately, then we are going to have an ineffective ability to enforce. But if maybe that's like a manifested issue because perhaps these other states that have never enforced or have never required firm registration don't have that issue. And so it could be fabricated. So that's just a thought. Logan.
Oh, thank you. And sorry if I freeze, that's my internet, not me actually freezing. So I think in a meeting, I think last meeting we talked about one kind of framing of how to target like firms to regulate. And that was the criteria of like, do they do a test, right? It's a pretty obvious one. And then the other one was, do they hold out as a CPA firm, right? And that seemed to gain some traction with in people's brains. And so that would exclude, for instance, a firm that's just doing taxes that's not calling itself a CPA firm, even if CPAs work for them. And so that seems appealing to people at the time. And so I'm curious what people think about that. And then as an add-on question, I'm curious if maybe Martin has thoughts on this or anyone really about whether that's coherent with the other state boards and how they act, if that's nationally a common way to handle things.
Mm-hmm. Thank you.
And Martin's gone.
Martin.
I'm still here. Sorry.
Okay.
Oh, there he
I'm
is.
still here. I just can't go on camera right now, but effectively, just to make it really clear, Logan, based on your question, the rest of the country essentially has settled into the space where they essentially regulate firms on the tax side of the equation only if they affirmatively call themselves CPA firms. That's essentially high level where the rest of the country is already at. For us, that's a big shift, but we would be aligning with the rest of the country if we go about it that way. It's just essentially a policy shift and one where and one where, you know, it'd probably be good to have real clarity from what is the comfort zone of the board so that the LRC can then kind of proceed accordingly with respect to coming up with a specific textual approach in statute and rule.
Thanks, Mark.
What do we think the issue, if we don't want to go that direction of aligning with other states, what do we think the issue is? It's just that then the only difference is purely between those that want to call themselves CPAs and those that don't?
Well, I think that whether you call yourself a CPA or not, I think that's so fascinating, this whole like don't use CPA on your like LinkedIn profile or whatever. Or is like whether you call yourself a CPA or not, if you still hold a license, you still are regulated.
Well, on the individual basis,
Yeah.
but for like firms.
Oh, I see what you're saying.
Yeah. Because I don't know if I necessarily feel strongly about just aligning with the other states that are doing it that way. Because again, the individuals are still within our purview.
Well, other states are continuing to regulate the attest side firms, but not the tax side firms. So in that APS structure, you have, you split off your assurance side and that's regulated, and the firm side, all the licensees, regardless of where they live, in which firm, they're all regulated, but there isn't like any sort of firm component. So yeah. Which in some cases, I keep going back to enforcement, and I don't know why I'm stuck on this, but like in some cases there have been where it's like we've had licensees who, I don't know, didn't give people enough time to review their tax return before having them sign their 8879. And it was like, well, actually that came down to like firm issue as well, because they didn't have a good system of quality control on getting that out. And so we had sort of extended, enforcement in that regard, which was, I don't know, I think it produces positive results, but.
Madam Chair,
Yes.
that last scenario that Logan put there regarding CPAs who do taxes for a firm that is not a CPA firm. Now, I understand at the individual level, we regulate the CPAs, but have there been, I believe there's been instances where we've extended something that's gone wrong to the firm.
That's right.
So if they're not regulated, how would that work? If somebody puts say they didn't do their CPE or their license lapsed, then the firm was totally responsible.
Right.
How does that work in our purview of being able to determine, what sanctions and who gets sanctioned?
Well, yeah, we wouldn't be able to. So like if we did not regulate on the tax side firms, and in an investigation of a licensee working for that firm determined that their internal processes were broken in some way, there's no accountability to the firm and no impetus for the firm to make any sort of change because we don't have any jurisdiction. So, I mean, yeah. Ray. Where do you go?
Well, I guess, as I've thought about this, Oregon is different than a lot of other states in that in Oregon, if you practice tax, you either have to be a CPA or a licensed tax practitioner. I think we do have a history of asking those in the tax space as firms to regulate, to be subjected to regulation. I also recall that I think there's language in the Uniform Accountancy Act, particularly related to when someone's practicing across state lines, that asks not only that licensee, but that licensee's firm or employer to cooperate with investigations. And I don't know if we have similar language, or we could, if we needed to, put similar language in our statute or in our rules. So that, I think that's food for thought.
Martin, you have some consternation around a differing approach than what is sort of seemingly happening kind of nationwide, which I know isn't because you're like, I want to be in the cool group, but has some actual like substance around why there's some consternation around kind of continuing this path of regulating. Can you talk a little bit about that? It's kind of after your conversation with Boyd.
Yeah.
Or maybe
so
you've changed your mind since then. It's a lot.
Yeah, that's the conversation with Boyd. Boyd is just for the record, Boyd is my colleague at the Alabama Board of Accountancy and a former chair of the Executive Director Committee. The conversation with Boyd was really much more along the very different discussion that I mentioned at the very different policy choice earlier, that where we talked about should we open us up to allow private equity as a minority owner in a firm structure, and Boyd had some concerns about that, and that was essentially the primary focus of my conversation with Boyd. It was not really on the issue we're discussing now, which is the should we or should we not align. Boyd has no, his state is, in terms of regulatory approach, a conservative state, and they essentially are very comfortable with only regulating firms on the tax side with respect to those that essentially are use the CPA title inside the firm name, right? For us, it's just an issue of, is the board comfortable changing direction? Because the price that we pay if we change direction is that we give up a lot. We have current authority over firms in the tax space, right? And fundamentally, it's a question, and that's the only reason I have hesitancy. I normally really like us aligning with where other states at, right? Firms like it when things are pretty regulated pretty similarly across state line. Licensees like it if things are pretty similar across state line. But for us, the simple truth is it's a huge policy shift, and it does mean that we would give up quite a bit on the regulatory side, right? And right now we are simply at that crossroads because we either give up what we've had, that broad ability to regulate in a tax space, for the purpose of achieving a policy goal of aligning with how the rest of the country approaches regulation of firms, or we say, you know what, we really like where we've been in Oregon and we want to continue, right? And that's really the fundamental question, and the only reason why I have hesitancy, because for us, there is a lot more at stake in that place than other states that either have never been or never regulated firms as broadly as we have, or have stepped back from doing so, like our neighbors up in Washington.
So yeah, I mean, so the if we like, it sort of sounds like we kind of like where we are, and we sort of would like to retain, and I think we've come back to that, and which is why then we've gone to the LRC and been like, can you make this so? And the LRC is like, kinda, yeah. And because the issue is, if we go that route, we need to make an adjustment to our 51% ownership rules, and then I mean, it's opening another sort of big can of worms. So we definitely are at a like juncture there. Logan.
A couple points, and I would love to hear Ray's thoughts on this. It seems like our current approach, more liberally defining the practice of public accounting, it does, result in some very hard statute and rulemaking for the LRC and for us to promulgate. So that's one thing. The other thing is, I'm trying to think back. I haven't been on the board for that long, but I don't. We've had enforcement actions against CPAs operating the tax space. We never had an enforcement action around like a non-CPA firm that I can recall. And I'm wondering how common that comes up. If this is like a thing we've actually a tool we've used in the past to regulate. Have we had a tax firm that maybe had a CPA working for them who we engage in an enforcement action with? Like is that in our experience, has that happened? Like, there's Haley. Everyone's moving around.
Logan, can I just ask a quick clarification? Are you
Yeah.
simply asking if there is history on our compliance side where we've sanctioned both a firm and an individual level CPE for a failure to follow professional standards in the tax space?
Yes, a tax firm, that's not holding out as a CPA firm. It's just like Jensen's Tax Services, and they happen to have a CPA there. Have we ever had an enforcement against Jensen's Tax Services?
That's a really good question. Because the way you phrased it is that if they actually use the CPA firm, and the issue is we would have jurisdiction under our current system if they're registered with us, and that does not require them using the CPA title in their firm. So that's a good historical question. I know that there's definitely precedent, and I don't know if I can put Jeremiah fairly on the spot here on this issue, because I know that there's definitely precedent with respect to us sanctioning a firm and a CPA for misconduct in the tax space. What I don't know off the top of my head is if any of that involved firms that technically did not use the CPA in their title. My hunch is if we go back far enough, the answer should be yes. But I don't have it immediately available, and I'm wondering if Jeremiah, if you can maybe take a quick peek at our disciplinary action report and see if you can come up with a potential instance there.
Yeah, I can take a look. If it's a firm that required registration, then the answer might be yes. But I'll look at the action report and see if there's any violations against firms in the tax space generally. And I'll chime back in when I have the answer.
Yeah.
Thanks, Jeremiah. And I think that for me is the kind of key question is when we're defining the space with which we regulate, if we're ruling in a space that we regulate, but we've never really had any use for that and like any enforcement action related to that, it seems like unnecessary, I suppose. And getting back to the distinction, you do a test or you call out a CPA firm. It's a nice bright line to like kind of pull people in and maybe a little easier for rulemaking, with maybe a question of downsides, whether they exist or not.
Yeah, I agree. I don't just want to sort of default to like, having control is better than not, or especially if it's if it's going to open up a big can of worms and it's not really super relevant, then I don't know, I'm more hesitant.
Yeah. Tanya?
I can't recall any times because we usually don't regulate like the firms that are not licensed or that are not registered with us. But the thing is that a lot of those firms that are currently registered that we are sanctioning wouldn't be registered anymore or could choose not to be registered anymore. So I think that's probably part of the bigger question is that there's nobody to hold accountable at the firm if something goes wrong. And like I think Haley stated at the beginning, one of the problems that we might see is that if we have a case and the individual is no longer with the firm and doesn't have access to the records, we're not going to be able to actually investigate the case. And then what do we do if it is a CPA that is being sanctioned for something? Because if they don't actually physically have those records because they're in the firm's hands, but it's not a registered firm, so they don't have to comply or give that former employee the information. I just have concerns about that.
Well, and I'm super curious, and I feels like we could find out the answer to this, but like, what happens in other states? Is that just like a question we need to ask? Logan.
And I wonder also, does the Board of Tax Practitioners, are they able to engage in enforcement action and investigations of firms doing tax services and not just the practitioners?
Can I just say we have a Chelsea M. Adams who just came into the meeting for the public record?
Yep, that would be me.
Sorry, go ahead, Jeremiah.
The tax board does require certain firms to register with them, so they would have some ability to do it, but the tax board, excuse me, the tax board only has jurisdiction over people doing individual taxes. So if someone did exclusively business taxes, they would be under nobody.
One thing I did want to point out is that we still have subpoena authority. So we still have the ability to subpoena records, but it's not as easy, right? Don't allow them to have video. Is that a choice?
Or talk, because they profanity.
That's already the setup. They're not allowed, nobody's allowed to share. However, what's happening is people can have a virtual webcam set up through their video. So
Yeah.
So you're gonna have to remove that Megan Kurz. That's not Megan Kurz.
Thank you.
Yeah. Gotta love a public meeting, guys. Wow, this is a good, this is quite the meeting today.
It was not actually Megan, for the record.
For the record, that was not Megan Kurz.
Yes,
That was
not me.
that was the person who joined earlier, then
So
took our
for
feed
people-
down and rejoined.
if people are trying to rejoin right now, what should I do?
Don't let them join.
Okay.
Angie, is that allowed?
It's a hard part with the public meeting side of it. But at this point, like,
They're late. So public comment has closed. And can we go into, we probably can't go into like an executive session and be like, all these people are allowed to stay. Yeah.
No, cannot do that.
So
Yeah.
We can't do executive session without notice, but
Yeah.
I do think that even though there is a public right to observe, that we can put that on the back burner so that we can continue with the business of the board.
Yeah.
Yeah. Agreed.
Okay, so just going back to
Where were we?
the subpoena power, I was just mentioning that we do have subpoena power to subpoena firms. Like, so if they're not a firm registered, we can still subpoena records. It's just, you know, then sort of like so we do have the ability to get records if a firm isn't necessarily having to be registered with us. We have the ability to try and get the records, but it's not going to necessarily be as easy, right? As if you have somebody that's registered, there's more of a duty, there's subpoena authority, and then there's the enforceability side of it too. But just so you know, we do have some ability. I just wanted to point that out.
Seems like it's my responsibility to somehow bring us to close here. And I don't know what our resolution is. Yeah.
It does feel like knowing what the other states are doing.
Yeah.
Would be informative. I mean,
I think so.
we wouldn't be recreating the wheel here, so it'd be good to know what they're doing.
Right. Martin, is that information that like you could like just kind of lightly pull from your executive directors committee of like, how does enforcement without them? I mean, they're going to be like, well, we just don't, I don't know. How do they deal with records of CPAs that no longer work for firms and trying to get access to that type of thing? Are they subpoenaing them, or are they?
Yeah, I can start working on
Or maybe
that.
you already know.
I don't know the answer off the top of the head, but I'm absolutely happy to work on that with my colleagues. You know, quite frankly, especially should we go down that road where the board says, let's switch direction and kind of align with the other states, then I would want to know the specifics of how other states do it, because it might impact how the LRC approaches this language-wise.
Yeah, I mean, I think while I want to keep everything as it is, I also want to put the private equity horse back in the barn, but we can't have everything we want all the time. And so there's a piece of like, I want the option to regulate and enforce and, do the things that we feel like we need to do and we have been doing. And also I recognize the significance of what we're up against in terms of ownership structures. And so like, we may need to change course, even though it feels like we're giving up control, and nobody likes that because we're accountants. I don't know who had their hand up first, Ray or Logan. So Logan, you're unmuted. Go for it.
Let's have Ray go first since I've talked.
Okay. Okay.
All right. Well, I guess the comment, Haley, I kind of personally agree with you about trying to get the private equity back in the barn. And in some respects, I've watched what Oregon did in this last legislative session with the medical profession, where they passed a bill to require majority ownership of practicing medical professionals in the medical practice. And where the horses are out of the barn, there's like a 3-year period for those horses to get back into the barn. But I think, Oregon has been different in how we regulate. I think we've had more regulatory authority than others. And I think it's a very serious question about whether we want to give it up. And part of the solution may be, if we were trying to get horses back in the barn, we give them an appropriate window to accomplish that task. It doesn't happen overnight.
No. Logan.
In this conversation, we focus on tax services, but there's many other services that you could think of as public accounting that we have written a circle around and said, yes, that's public accounting, and that's just like a whole other can of worms too, to deal with. And I don't know if I can put a succinct argument together for what I'm about to say, but I have a feeling that the way we are regulating things in light of the PE issue is not sustainable and too hard to define. And what we are regulating could be construed to be almost anything you do for someone else that involves money, like banking or something like that, or investment advising. All these things like very quickly can be construed as public accounting. And so, I could see defining something maybe to include tax in that circle of public accounting, but like other things, consulting and bookkeeping, and I don't know, those are all really hard to see as something we can regulate. And I think right now, those, in a lot of ways, those can be construed as public accounting. So I think we're in a difficult spot with what we have, and I think we've kind of defined public accounting too liberally. And hence it's very hard to define what that is. And we've seen a lot of people coming in front of the board with issues where they're just working as like a controller for some company, and then suddenly they're in trouble because they're a CPA or lapsed CPA. So I think it's a issue that we're gonna have to address. And I tend to think, we might have to circumscribe how we define public accounting going forward with private equity happening.
Yeah. Martin.
Yeah.
So where did we land? I think that we landed, I think, Logan, I think you're right on about the definition of public accountancy, that we kind of we've come back to this on multiple occasions. Yeah. I don't know where we've landed. LRC just doesn't know where we landed because we don't know where we landed.
Well, do you
Thanks,
want to,
Haley, that's fair.
do you want to just go around and just ask individual board members, hey, what's your preference here?
I don't even know what the question is because
that's what I was going to say.
I think
could we circumvent on the question that we're trying to answer here?
I think that the question, I think I know what the question is, and I think I think the question is, do we want to regulate PE owned tax firms? And the answer is maybe. We might. We kind of think we want to, but the reasons we think we want to maybe aren't founded in actual like can we still enforce the appropriate things we need to enforce without that sort of firm registration piece? Jeremiah.
So I look back through the disciplinary action report. The bulk of the firm violations are around test work, but the ones that are not are typically more administrative, like they didn't register or they used CPA and associates when they only have one CPA, or they didn't respond to the board timely. There were a few where the case was brought against like an owner of a firm, and then it extended to the firm when they did something like filed extensions for a bunch of people that were not their clients. But typically the tax stuff is all against a person.
Jeremiah, that example you gave of extension to the firm, was the firm, it was a registered CPA firm.
Yeah.
Is that correct? Yeah. With that example you gave, or that.
Yeah, the only times that we've done anything to a non-registered CPA firm is if someone is not a CPA, is not registered, and they have CPA in the name. Or their owners are holding out as CPAs, that kind of thing. But even when they are a registered firm, if there's a violation around like a return itself, or there were some people doing like kind exchanges that extended to the firm only on the administrative side, and the bulk of the violation was against the individual who was performing the work.
Thank you, Jeremiah.
Thanks. Elizabeth?
So I wasn't sure if it was appropriate to raise this question, but it seems to me that part of the issue here, and as background, this is something I've been working on from an academic research perspective for nearly a year. And part of it, so there's two issues I want to raise just for food for thought around this. From a public protection perspective, when individuals look at a firm that is an alternative practice structure, it appears to be one firm until you read the very, very fine print. So again, that doesn't get to how you regulate, but it does seem to be something that is prudent to keep in mind. The other issue that I would raise is that what might a non-regulated firm lose that could hurt the public? So you're looking at this from an enforcement perspective. But what if all these tax firms no longer are registered firms, what might they stop doing in terms of their quality control and so forth? So just a few more questions that are food for thought.
Yeah, I mean, I think that I don't know how we can't draw parallels to kind of the medical profession and say, well, we believe that there's going to be some deterioration of quality when there's this private equity ownership potential and all of the things. And then we try to rely on, well, individual licensees are, on the hook. And it's like, well, individual licensees have jobs and they're getting paid by somebody, and people, they're yeah, like we can only expect so much of the individual person when they're trying to deal with their livelihood as well. Yeah, I'm obviously very conflicted on the matter about which direction to go, because I mean, Logan, I think you're totally right about the sustainability of it all. It's like, where does it end? The circle just continues to get wider, and the next thing you know, we've got, I mean, yeah. I think the definition of what it means to practice public accountancy is a thing that needs to be looked at. And although I guess if we have CPAs that are in a firm and they're doing bookkeeping and outsourced, CFO work, like they should behave also in the construct of their firm. So, Logan.
So maybe like, concrete examples might be helpful for the debate. So for instance, we have a tax firm, loosely defined. It's 3 people, they're LTPs, they're doing taxes for people. None of them are CPAs. They're not holding out as CPAs. Are we regulating them?
No.
Then take it to the next step. They add a CPA, but they don't call themselves CPAs. Are we regulating them? I mean, it just like trying to think of like specific examples of like an investment advisor or a tax preparer. At what point should they fall into our jurisdiction?
Mm-hmm.
And on the second example, I believe the answer is no right now. If all they do is pull in a CPA, but they're not essentially a CPA firm, and they just happen to hire a CPA onto their staff, doesn't trigger a firm registration requirement with us. And Jeremiah, please, quality control, check me here if I get anything wrong here, especially live.
No, you're right. You're right on.
And in that last example, I guess the CPA would be under our purview, but none of the other individuals at the firm, and not the firm itself. If they're only doing individual tax work, then they would fall under the tax governing body.
Well, is that true? Because I thought that the non-assurance firm in the alternative practice structure is required to register but can't because they're not CPA owned 51% by CPAs. And so the reason they're required to register is because they are a CPA firm. And so what defines that?
So
nobody knows.
I think, and Angie, you might have to sit in here for a minute, right? I think what you're talking about is the issue that effectively we have unfortunate language in our statute that allows the non-attest side of the PE firms to come in and simply say that they are not a CPA firm because they're not majority owned, and that's the reason why they don't have to register. So even though they're chock full of CPAs, they're doing tax work, which is part of our definition of public accountancy, their argument is that the way our statutes are written right now is that they don't have to register simply because of the fact that they're not a CPA firm. I see Angie nodding at my explanation, which doesn't happen all that often, so I thought I would at least point it out.
Yes, that's where we're at.
So the key distinction is that the non-attest service providing firm is a separate entity from the CPA firm. So, you know, not to pick on Curtis Stokes, but there's Curtis Stokes CPAs, for instance, you know, not this made up. Curtis Stokes CPAs, and they're a CPA firm, they do a test. Then there's Curtis Stokes LLC or something like that. And they're doing non-attest.
Right.
And the reason we're not regulating that non-attest Curtis Stokes, because they're a separate entity.
Mm-hmm.
And that's it. Like, you know, and that's not crazy.
Well, and in your scenario, Logan, then or in both scenarios, are the members that all CPAs or no, or I guess a mix it could be? Because then the CPAs would be individuals, they would be under our purview, but not the members that are not CPAs. They would be sort of scot-free because we don't have anything over them individually, and the firm.
Yep. And so maybe I'm meandering towards a point is that, like, the reason why we're having trouble coming up with an alternative to you do a test or you call yourself a CPA firm. The reason we're having difficulty coming up with another alternative is because it's really hard to develop that.
Yeah.
It might not be feasible in reality.
Oh, good, Martin's. It's just Martin joining us.
I
Oh, good.
I took a risk.
Thank you. Thank you for taking that risk. Oh, good. I like it when I can see Angie's face. That we know if we're like.
Wait a minute, you can't see mine. I'm assuming that's a good thing.
I like to see yours also, but I feel like Angie lets me know with her face if we're running afoul of something.
Okay, so let's do this. My laptop decided it wanted to run that way.
Echoing.
Yeah, it's between Angie. Okay, hold on.
I'm
Now one of you two has to unmute so he can talk. Martin or Angie unmute. Martin unmute.
Okay.
Now
There-
Jason can talk.
Now
There we
good?
go. Now we're good.
Okay, then, Madam Chair, if it's okay with you,
Mm-hmm.
I will not use my laptop. My apologies to the group. It decided it wanted to reboot and do an update. So I will still be here. I'm still present, but let's just run it off of Angie and Martin's, unless you want the laptop back up.
Are you connected, Angie?
Oh, you're fine.
Okay,
Yep,
then
Angie's here.
we'll use Angie's connection, and I'm gonna hang up here.
I also like to see your face, but okay.
Well, he can sit next to her.
Yes, let's just sit next to sits next to Angie. Okay.
Okay, now use it.
Super. Okay. I thought Jason was going to try to synthesize what we have discussed, and I was ready for that. That wasn't it. Yeah. So yes, where are we? Where are we? Does anybody know what's happening?
What we're missing, what we're sort of circling around is like a gap analysis. Like in terms of like what if you do the Venn diagram of all the various options, what leaves someone just like, or the insides of a firm where, you know, people aren't regulated by either us or our tax brethren, and then based on what has happened in enforcement actions previously, do we really care? I don't know. I guess that's where I was sort of in.
I think that's right.
Well, and also the sort of bigger picture of like the 51%, right? Like that's really what our biggest, if the 51% ownership requirement wasn't there, what does that do? Right. And so I think that's the hard part too, when it comes to when you are doing a test, that's the reason for the 51%, right? But then if you're not doing a test, you know, then do you need the 51%? And I guess maybe do we come up with two structures?
Yeah,
I don't know.
Structures that, for example, could be like, okay, you are a licensed CPA firm because you are essentially a traditional CPA firm operating in the tax space, and you are registering, you know, you're registered with us. That's essentially our traditional form of firm license, and that we come up with a different type of license for those that are not CPA. owned, right? That is essentially would be the other way, because the only way a regulatory board gets jurisdiction over anything is if there is a license you have jurisdiction over, right? That's the fundamental gateway. So we could also decide to say, you know what, we're not going to try to issue an APS entity a regular CPA firm license, but we could decide to go, a completely different route and basically create a license type for that scenario specifically that allows us a level of jurisdiction, right? That we would have to write into the
statute.
Right? That would have to become part of a legislative concept, right? It would also mean that, and I don't mean this negatively, I just want to be clear about that we would be, from what at least current state, be the only jurisdiction actually trying to step out and basically saying, you know what, you still walk like a duck, you quack like a duck, you're still a duck with respect to you're chock full of CPAs doing tax services, therefore we want to regulate you in some way, as opposed to doing what other jurisdictions are doing, which is basically accepting that these are not entities that they're regulating, whether they're APS owned or not, just because they're not regulating the tax space very much. So that is a policy choice that we could make, and that's the only one in which we would have some level of jurisdictions over PE-owned entities. That's essentially without saying that these are CPA firms specifically that are subject to the 51% ownership requirement. We could create a different type of license for them.
Madam Chair, the way I see it is that when a non-owned CPA firm, we keep saying chock full, to me that means a bunch of CPAs. But if a non-CPA owned firm hires CPAs, several things happen from my perspective. One is that they're going to get the benefit of professionals that are going to bring that to the table. That's why they hired them. And so there's a level there that they've stepped up. They just don't have somebody who passed the tax test. They have an actual certified public accountant in their firm or more. So they are going to charge more. They're going to be able to put out more services that a CPA might be able to do, non-attest, do more complicated things for businesses. So shouldn't we take that into consideration, the fact that that particular firm has to take some responsibility for those CPAs and what they're doing under their purview? And if a CPA goes rogue, hopefully they'll get reported at the individual level. But if that firm sanctioned that rogueness, there's got to be a way to sanction those owners, because they basically used a license to their advantage, whether it was good or they ran afoul of the regulations. And so I don't, like we've mentioned before, we haven't seen a lot of that. It's mostly been extended to CPA firms that are registered. But I take my firm, for example, I'm registered. I'm the only CPA, but I don't do any attest work. But I choose to register because I put a certified public firm under my logo and everything. I'm holding out. But those individuals that are not doing that, those owners, and this is a question, this is just something I'm putting out there, shouldn't they have some responsibility for the CPAs doing CPA work? And again, it goes to the definition of public accounting. They're probably doing tax work mostly, but I would assume and I believe that they are doing it for businesses, and a business is a little more complicated in a lot of respects than an individual tax return. And so they're performing a duty, a public accounting duty, I think. So that's a question I just want to put out there and consider that relationship between the non-CPA owners and the CPAs they hire for whatever reasons.
Logan?
There's a follow-up on this discussion is we should be careful following this line of reasoning if private enterprises by dint of hiring a CPA are now put into a new regulatory regime that they have to deal with and the burdens of that, then there'd be a disincentive to hire CPAs, which be a little counterproductive to public protection.
Right.
And so like any definition where it's like, oh, you've hired a CPA, now you're a CPA firm,
Right.
I worry about.
Mhm. Yeah. Megan, is
Well,
that going to be your
Well,
comment?
and I guess one of my thoughts too, I mean, again, just sort of making some points here, whether valid or not, is like, it is one reason that they're hiring them is for their specialty, and potentially the owner might not have the same level of specialty and be able to say what you did as a tax practitioner was right, wrong, or indifferent, I mean,
I'm wondering, Jeremiah, are you trying to address this all? Or are you?
Yes, I hit mute.
Oh, sorry.
If a non-registered firm does business taxes and hires a CPA to do the interviews for incoming clients, that client, if they Googled the person they just talked to or looked them up on our website, will see they're a CPA. They are given the perception that CPAs are involved in their business taxes being done. That work is then handed off to anybody supervised by no one. It doesn't matter. That public is now potentially being harmed if that person messes up the return. That person is not being supervised by a CPA. The public thinks it's a CPA. The tax board doesn't care because it's a business tax return. That public person makes a complaint and it goes nowhere.
So just for the public record, I completely agree with everything that Jeremiah just said, except for the phrasing of the last sentence of the tax board doesn't care. It means they're not.
It's not under their umbrella.
It's not in their umbrella. It's not under their jurisdiction. So I just don't want it to look like we're maligning another state agency. They're simply not allowed to look at it because it's not in their jurisdiction.
Right. Yes. Megan.
Thank you. Sorry, I just wanted to comment. I really appreciate Raul's perspective, because I think what it really did for me, at least, was highlight the fact that there are scenarios where a CPA firm will enjoy the benefits of marketing and the perception of being a CPA firm, however, without any of the ramifications of potentially having to really comply with the board's standards.
Yeah. Okay.
So if I may, this is leading to alternative definition, right? So you're a company, or I guess individual, that is doing some sort of financial related services for others, for clients, right? And once you add a CPA to your roster, you are now a CPA firm. That is kind of the direction that's going there, right? And so that maybe is another definition we could consider whether that's feasible. But at least, I mean, that's the most specific alternative I've heard so far.
Mm-hmm.
That's kind of already in the rule. The registration of business organizations, there's 4 things that would tip you over the scale. You use CPA, you hold out that you are engaged in the practice of public accountancy, you hold out that you have more than one licensee, or you do a test. So if you're saying, hey, we do public accountancy, which the way that Angie, I don't know if I'm right, but the way that I've interpreted that is if you hold out that people in your firm are doing things that fall under our definition of the practice of public accountancy, by saying there's a licensee doing some of these services.
And that there's more than one, I believe, is the other thing that the board has looked at.
And there's more than one.
Yeah.
Interesting. Tanya.
I'm going to give another example as well. So like our firm, which does government consulting, I have non-CPA owners. And like if we ever went above the 51% with non-CPA owners, we wouldn't be able to be registered as a CPA firm either. And so I'm with Raul that like we want to be registered as a CPA firm. People come to us because we have CPAs on staff and because they know what that stands for and what that means. And so, I mean, I think in the future, I don't know if we'd still qualify as a CPA firm potentially down the road if we have more non-CPA owners. And so I kind of like the option of having two different ones, and maybe it's something different. Maybe it's not a CPA firm. Maybe it's just some sort of registration or something like that, that then there's an individual associated with the company that is overseeing the CPAs that are practicing public accounting, that way there's somebody in the firm that is held accountable in the example that was just given, where it's like a CPA meets with the person, but then that CPA never touches the tax return ever again. But that way that there's internal controls and things like that we can potentially go back on that company, whatever it is, firm, I don't know what you want to call it, but I kind of like that, the way that this discussion is going.
So I think what I heard you say, Tanya, is that you're hearing kind of broader support for maybe like two types of licensure, like one for a traditional CPA firm on the tax side, and then one that allows some level of registration and accountability structure for something that's not a traditional majority-owned CPA firm, but essentially gives us a way to have some level of jurisdiction and accountability in that space for the, let's just say, non-traditional structures, regardless of whether that's a PE-owned entity or another entity that is in that space, but is not, majority owned by CPAs, but has some CPAs doing work for it, is kind of what I'm hearing here. But I want to make sure, because we have, we're 10 minutes away from time, Haley, if you're willing to kind of pull that notion, and then also if we have enough time, get to the place of what that means with respect to, do we want to continue pursuing a minority PE ownership, or does that approach, if there is agreement that let's go down that road, if that essentially nullifies the other piece?
Yes.
I hope that makes sense.
I don't know that I'm totally following.
So I guess what I'm asking is, would you be willing to just pull the board on, are we reading the room correctly, that there appears to be a policy preference for continuing to regulate the firm space, including the tax space broadly?
Yes.
And with that, open up an option for the firms that cannot meet the 51% ownership requirement, but that operate in that public accountancy space, to get access to essentially a different type of registration, like lower level license, if you will, that allows us some jurisdiction at the firm level so that we can maintain that jurisdictional reach for those that are not 51% CPA owned.
Logan.
I would, subject to concerns around incentives this could create to hire or not hire CPAs. I think it's an attractive idea. So it seems worthy of exploring. Yeah.
I think do we think the right people will continue to register or not? And maybe that's a dumb question because yeah, I don't know.
Well, and I guess like the lower level licensure, is that going to give, like Tanya, in your example, does that give meaning to you if you no longer meet the 51, if you know, whatever it's called, it's not called a CPA firm. And so people might not give that any additional weight because it doesn't have any meaning to them. You know, I mean, especially if we're the only state that has such a definition. I just wonder if it does, if that would do what currently being able to call yourself a CPA firm does. Right. I mean, I think it warrants consideration, but just another point of something I think we need to be. I'm just cautious of like over engineering it a little bit, especially because things could change from here, you know, like.
I think the definition would have to be spelled out, like what public accountancy is, what for like name of firm or company or whatever, that like there has to be more than one or still, or some of those things around those things. I don't know. I just think it's an interesting option potentially.
Totally. Yeah, I was just playing devil's advocate a little bit.
I like it. Good questions.
But yeah, it does sound like there's some consensus around continuing to go
Try
down
and regulate.
this path, and yeah.
Logan.
And Ray, you know, with his duties in the LRC, I'm curious if like it. Can you give us like the questions? Questions. If there was a question we could answer for you, what would it be from the board's perspective?
Did you just okay?
Ray or Jason, yeah.
Well, my question is, what is the board's direction? What would you like us to do as far as rulemaking or drafting statute with regard to this issue? And what I'm hearing is fabulous discussion around a very difficult issue.
Really?
But I still haven't heard Jason take this and go forth and do that.
Yeah. I think that your takeaway is accurate.
Okay, I wanted to make sure that I hadn't missed something because I serve at your pleasure.
Yes.
He serves at the board's pleasure.
I think we're inching closer though.
Yeah.
So
Elizabeth,
if I may, I think there's one other factor here that could be helpful in the Laws and Rules Committee thinking about this. To the extent you have firms that are affiliated with a regulated firm through an operating agreement, that operating agreement, it seems to me, provides the justification that, again, not an attorney, so Angie, I'm sure their attorneys will figure out ways to try and wiggle around this, but it's clearly that they are in some way trying to affiliate with a CPA firm. So for a firm that does absolutely no attest practice, that is just doing taxation, that's very different than a firm that is like all these PE firms. They have an attest arm, they have a non-attest arm, and there's no equity, virtually no equity sitting in the attest firm. There are no employees other than a handful of partners. Everybody else sits in the non-attest firm. That was intentional in setting up these structures. If you listen to the deal makers are very clearly trying to strip the assets out of the attest firm, in part for legal protections. And so that could easily, it seems to me, maybe not easily, but it seems to me that is a potential avenue for the board to go in and say, this is, you know, we said we had 4 things. Well, if the 5th is that you have an operating agreement with a registered firm, with a licensed firm that is doing attest, that then triggers the need for a different license and does not require 51% ownership. Maybe I'm oversimplifying it, but I wanted to throw that out there.
I like that. Ray.
I mean, there's armies of lawyers that have put these deals together.
Yeah, they'll find a way, but
Well, I think Elizabeth's right in terms of there's armies of lawyers, but I think in terms of direction, a little bit of what I'm hearing, and Jeremiah, you were helpful when you kind of said, in your mind, you got these 4 criteria.
Yeah.
You've got CPAs together, they're holding out to the public. It's not like a CPA performing services only for their employer as people do in industry and government. That we've got a series of criteria that we can spell out that this represents, if it looks like a duck and quacks like a duck and walks like a duck, it's a duck, and these are the criteria for being a CPA firm. And I guess if I'm thinking, listening to the conversation, that maybe the next step for the LRC, and Jason, I'm going to put words in your mouth and you correct me, please. Because I think, what are the criteria of what we're concerned is a CPA firm performing tax work, and I'm going to just say tax work, not, we're going to leave the consulting and the other things off to the side.
Yep.
That CPAs doing a test, CPAs doing audit work, what does that duck look like? And what's that, and if it walks like a duck, let's define the criteria and say that's the firm that we're going to regulate. And maybe the job of the LRC is to come back first with, kind of a draft of what does the duck look like?
Yeah, and I think Elizabeth's comment about that affiliation, I don't want to use any variable interest entity type language, but it's like what it's that affiliation, that relationship look like, and if it's simply an operating agreement that connects the two, having that pulled in, because that's to me, that's the risk is with those firms, right? That's where I feel like we're going to lose quality. That's where I feel like the public is more at risk than, Raul's firm. Like, I mean, there's just it's just a different animal. And I don't think that we can rely solely on the CPAs that work in those firms to uphold the level of quality that we need and are required. So, I mean, I think that, Ray, I think you kind of hit it on the head there, that we got to define the duck and figure out how we pull in this subsector is really what we're trying to pull in.
And I think just as an example that really highlights this fact, when you're talking about non-partners for certain, they're who are doing the attest work. They are employees of the non-attest firm whose compensation is determined by the non-attest firm and whose employment is determined by the non-attest firm. They are leased to the attest firm to do the work. If that isn't form over substance, I'm not sure what is, but that operating agreement is what gives you it's a legal agreement. It seems to me that gives that 5th prong of what this is.
Yeah. Mm-hmm. Yeah. Ray, do you still have your hand up? That's okay. Okay. Martin?
So I think
Jason, Orem, are you all so crystal clear?
Well, I think we're clear enough to at least understand the fact that there is an interest. So I'm going to try to summarize. I think there is an interest by the board for the LRC to go down a broader policy approach that's more in line with our past, saying we would like to continue to regulate the tax space broadly, which effectively means not aligning with what's going on in other jurisdictions. I sense a comfort zone there, and that we actually try to flesh out at the LRC level what this 2-type license structure could look like, so that we could try to pull in stuff that are not traditional majority-owned CPA firms, but are clearly operating in that space and have that level of accountability and see if we can flesh that out. I'll go one step further. I didn't hear any clamoring in these last 90 minutes for, if we do that, that we also try to permit the minority PE ownership of the of an actual registered CPA firm. So I'm kind of, I haven't heard any discussion around that piece. So I'm kind of more inclined to say the priority that I'm hearing here today is to really work on the firm registration side and kind of how we can continue to kind of have that broader jurisdiction, and put the other piece about the minority ownership structure changes more on the back burner. I'm not sure if I'm reading the room right there, but I just didn't hear any. I didn't hear much discussion on that second piece.
Yeah, I think you're right. Anybody disagree? No. Okay.
Because that'll focus the work that'll help us focus a lot at the LRC level if we can kind of pivot more to that firm registration piece, including the ability to potentially have some way of regulating the APS-owned entities.
Right. Yep. Okay. We're over time. Thank you, everyone. Appreciate all of your insights. Super appreciate you guys coming and having this discussion.
And Shelley, thank you for not storming out of the room.
Shelley, oh my gosh. Welcome to our board meeting. Not always like this.
No, this was very tame. Thank you.
Thanks, guys. Appreciate it. Thank you, LRC.
Thank you all. Appreciate all of you.
Bye-bye.
Bye.